Okay, thank you very much for joining this ATMA Asia Talent Mobility Alliance webinar. Very good to have all of you along, and I'm joined today with Debbie Baynon, Director of Immigration Services at Crown Worldwide. Debbie, thank you for making the time today.
Thank you.
Great
Lovely
to
to
have
be
you.
here.
Okay, we'll get underway. Just a little bit of housekeeping first. This will be recorded, and we will send the recording out to all people that are registered today. If you do want to ask questions, you can. Please enter your questions into the chat or the Q&A chat box. And we will sort of deal with those questions probably towards the end of the presentation today. We've got quite a bit to get through. Renu, can you take us to the next slide? So just a little bit about ATMA. Briefly mentioned a little bit about ATMA. So we have lofty missions and things which you can view in the presentation later on, but we're really here to enhance the innovation and development of talent mobility in Asia. So that's what we're here to do. So today we're talking to you on immigration topics, helping you to understand the immigration landscape here, well, globally, but with a big emphasis on how things are going here in Asia. You're probably aware that ATMA has four pillars. So we have ESG and sustainability, advocacy, education and development, and events and networking. So if you are perhaps interested in getting involved in any of those pillars, please do get in touch with us. We'd love to have you on our committees that are supporting those pillars. And we'd love to have your support. Okay, listed up there, we have about 10 items I think we need to get through today. So quite a bit of content to get through. So I'll let you get things underway.
Thank you very much. And Renu, can you move to the next slide, please? The main topic that I'm really looking to cover today is compliance. I think a lot of you will be aware that compliance is a critical issue for immigration. Renu, the slide hasn't moved forward. So I think the first element that I would like to cover essentially is the landscape, the compliance landscape. Immigration authorities are shifting from policy guidance to active enforcement. Things like audits, inspections, border security are now essentially routine, supported now by data analytics, cross-agency information sharing, and coordination, and also retrospective reviewing. The tolerance for historical grey area practices are narrowing, and are narrowing quickly, especially where business travel and short-term working are involved. They're resulting in much more refusals, a lot of detentions, penalties being awarded, and reputational exposure to clients. From the technology perspective, biometric systems, digital visas, e-arrival cards, automated tracking have reduced effectively the discretion and the ability of people to essentially be non-compliant. And it's more likely that non-compliance is going to be identified, sometimes retrospectively. Authorities can now reconstruct travel histories, digital arrivals, in and out, it can be tracked, and actively tracked even after the event. So if somebody's arriving and an immigration officer's not that happy, they can look very, very quickly and see what the history of that pattern is. Next
A lot of
slide,
this,
please.
Debbie, is quite sort of grey, right? So how do how do
Yeah,
you
I mean,
manage,
grey,
compliance when things are so grey?
yeah, grey areas where the law is unclear and essentially regulations aren't applied consistently are rapidly evolving. And really now they're very dependent on interpretation. So grey areas are never ever going to be eliminated, but they can and must be actively managed. Authorities are expecting both individuals and employers to demonstrate intent, diligence, governance over the rules, and essentially use a plausible interpretation. So where the registration is unclear, regulators will expect employers to adopt a conservative approach to any grey area. And essentially from an employer perspective, should not be ignoring grey areas. If they know that there is an issue or that a business traveller potentially is going to be doing something they shouldn't, it needs to be essentially the employer that stops them.
Right. Okay. So how are sort of governments these days improving their ability to cease the misuse of business visas? I know that you've mentioned biometrics and things in the previous.
Essentially, from a governance perspective, pre-arrival and on-site screening are really, really becoming a big issue. Because of the digitization of arrivals, especially departures, immigration officers have more time now. You will see them standing around. So officers are now conducting expanding profiling. They're doing investigative interviews if they're not happy. And essentially, just to give you two examples, Singapore. So now in Singapore, the Integrated Targeting Center, which is called the ITC, is using advanced passenger information and data analytics to identify essentially high-risk travelers before they travel. They're sharing information with airlines. The aim is to try and stop essentially travelers that the Singapore authorities do not want to arrive to even get on that plane in the first place. Right. In Australia, as recently as the 14th of March, there's been some legislation put in place whereby they've introduced what's called arrival control determination powers. So that essentially gives the Australian authorities, regardless of whether anyone has a visa or not, to make a decision on whether that person can be admitted or not. I think that is partly a reaction to the current situation that's going on with the war in Iran, but they have implemented legislation that's allowing them now to control arrivals, even if there are visas in place.
Wow, okay. Things are getting more strict, it seems.
It is, yeah. And from the perspective of employers and work permits, basically, again, it comes back to auditing. Essentially now, the authorities are keeping a very close eye on things. So as an example, in Canada, now up to 25% of foreign employers are using foreign worker programs, and auditing is taking place on site. There are fines, which you'll see in the next slide. Fines are being levied where the regulations aren't being left. And it can also include a fine or a ban even. In the UK, penalties have increased. And again, you'll see this in a second. In the US, I think everyone is aware that there's been a lot of checking in relation to people arriving, and things like social media, handheld devices are being checked as people arrive. Moving on to business traveller and visitor misuse. I mean, business travellers have always been an area whereby it's a grey area that we just talked about, but this is one of the highest risk areas in the compliance landscape, essentially. When you're looking at things, common failures are essentially people not being assessed. And essentially, people are doing frequent visits and authorities are looking at that. Thailand is a very good example of that. Thailand has actually started to look at what they call visa runs, and they are keeping a very, very close eye on people who are arriving, maybe staying 30 to 60 days, and then leaving and coming back either the same day or the following day. If you do that more than once or twice, you are not going to be admitted. And that is something that's relatively new. They want people to get the proper visa for exactly what they're supposed to be doing. So business travelers need to be very, very careful. Around remote work, there's been quite a lot of kind of, again, misunderstanding, maybe not fully understanding what the requirements are. So the reality is that physical presence in a country does usually mean that that's considered work. And employers thinking about working remotely, you can't assume that remote is an immigration neutral situation. It's not. A lot of employers aren't even necessarily aware that their employees are working remotely. They think they're at home working, and they're not. They're somewhere else. And employers don't always know this. So there's a lot of tightening happening. And that includes scrutiny in Spain, in Portugal, Thailand I've already mentioned, and parts of Eastern Europe. Another area that's really, really kind of difficult is right to work. And we will come to this in a little bit more detail a bit later. But right to work essentially means that the person themselves in that country has to have the right visa in order to be able to work. But equally, the employer has an obligation to ensure that that person has the right to work. And there's a lot of risk around right to work checks, especially when people now are arriving digitally, where there's no real stamping of passports, and also from a data protection perspective. So there's quite a lot of misrepresentation happening in relation to role descriptions. And this is starting to be challenged now by the authorities. Mm. So Renu, could you perhaps go to the next slide, please? This slide really is highlighting just very, very quickly those compliance penalties that I mentioned. The first one there you can see is a £45,000 sterling wow. Kind of fine. That is for the employment of an illegal worker in the UK. Right. That is the first fine. If an employer is found to have more than one illegal worker or a worker that doesn't have the right to work in the UK, the fine will increase to £60,000 sterling. So there is a huge amount of risk in relation to right to work and ensuring that people are properly documented. The second one is Canada. That is 1 million Canadian dollars in fines. And as I mentioned, 25% of employers are now subject to audits. So it's critical that people are actually properly documented and that employers have that documentation available in order for those audits to take place.
When it comes to Asia, Debbie, is there any sort of countries where prominently you see penalties and
the right to work? I think, again, it's one particular area is China. The Chinese are now able to travel a lot more freely than they've ever been able to. A lot of countries in the Asian part of the Asia and APAC have now allowed Chinese to travel as visitors, visa-free, for short periods of time. And we are seeing that is being used in order to essentially allow people to travel and potentially start work, and then look to perhaps regularize their stay after they've arrived whilst still working. or they're doing short project work. They're doing things essentially that they shouldn't be doing on a tourist visa.
Right. Okay.
Renu, could you perhaps move to the next slide, please? So this really slide is looking at compliance and where the areas, snapshot areas of where things are potentially at the minute the most acute. The US is the first one. You're looking at I-9 audits, business traveller misuse, and very much heightened border security. I think we've all seen the kind of published articles around the ICE and the work that they've been doing in the US in relation to picking up illegal entrants and deporting them. UK and Ireland, very much around right to work errors, not actually checking properly. We've had sponsor license revocations in both the UK and in Ireland. So the UK Border Agency is revoking licenses where people are not, or employers are not abiding by the regulations. Digital status failures, essentially, again, related to right to work, where people say they have the right to work, but they don't, and the checks aren't being made. Canada, which I mentioned again, auditing, looking also at wage compliance. A lot of countries have minimum wages, and employers are obligated to pay those minimum wages, and they must do that, especially where people are on visas, and that there are declarations to authorities that that wage is being paid. Role compliance, role drift. So when you have a visa, you are submitting an application for that visa for a specific role with specific responsibilities. And in Canada, there's a lot of role drift. There's a lot of things moving on where people are actually doing things on a wider scale, maybe that is not essentially listed in their original responsibilities. And also retention for the LMIA, which obviously is the labour market assessment. So that's done essentially, which is the labour market testing, but the authority, the employers are not retaining the proper documentation in order to prove that they've done what they're supposed to do. For the EU and Schengen, again, visitor misuse, obviously there's a wider issue now. Exit controls and entry controls are now in place in both the UK and in Europe in relation to people coming and going. Those are all relatively new now. There's been a period where after Brexit where there wasn't really any checking. Now the checks are there in place and people are coming and going and doing things potentially that they shouldn't be doing. Posted worker rules are another thing that really is being kind of not used in the right way. And biometric tracking, which is now obviously starting. For us in this region, again, like I mentioned, very much about remote work ambiguity and misunderstandings around the ways people are coming and going. The use of employers of record or nominees, that's another big issue in relation to this part of the world. Some countries, Singapore being one, actually have now said employers of record, we will not entertain that at all because there's too much ambiguity going on about who actually owns the visa itself and the fact that somebody's working for someone else. And work location breaches as well. Indonesia is a good example of that because you have to have a specific location nominated when a work visa in Indonesia is actually issued. And if that person is responsible for more than one location, that should be essentially detailed on that work permit. But if they then go somewhere else and go into the office and the immigration authorities either hear about it or know about it, essentially that is a breach of that work permit. And that can be penalties for that. And globally, again, coming back to digital nomads, the misclassification of them and what they're doing, and the cross-border remote work. So those are the critical areas that we're talking about. moving on now. This is really about compliance and compliance hotspots. So essentially,
Sorry,
what we're
Renu,
talking about now.
did we just skip a couple of pages there, Renu? I think that's the one you need to be on.
Yeah, so
excellent.
So this is about essentially compliance hotspots. We've talked about it, but remote, these are countries where you've got some issues. So in relation to ambiguity, essentially remote work. There's no visa in Singapore, as an example. And the Ministry of Manpower are matching data to people coming in and not. So essentially, there is a lot happening. There's no visa. Productive work in Singapore generally requires a valid work pass. And the common theme or the common thought that's coming through is that any short-term presence and somebody being paid outside of Singapore doesn't count. Yes, it does. Mm-hmm. They are working, and essentially they are working outside of the real authority that is granted in Singapore. If you look at Malaysia, there is.
Last year, when you had there was a notice put out for photographers and video, people doing video jobs and things from out coming to do those jobs, from other countries in Asia to Singapore. And Singapore pointing out that that is working in Singapore and you're taking locals' jobs, so therefore, don't get caught. Don't get caught.
It's a good point. If that is done in relation to one specific event, as an example, so if one of the big brands, as an example, comes in and does a show, then that is okay. They are then work exempt. You have to get the approval, but they are work pass exempt. If it's one show for one specific area, but if they're just coming in to do that work for any length of time, then you're right. It's against the requirements. The second country I'd quite like to highlight is Malaysia. There is a digital nomad. It's called the Duranto visa, but the eligibility for that is very, very narrow. And it isn't retrospective either, which means you need it before you arrive, and you can't just come in and think that you can get it afterwards. So working remotely on a visitor pass in Malaysia is not acceptable in relation from the authorities' perspective. From the enforcement perspective, what the authorities again are doing, they're looking at frequent border entries. They're looking at people who are using co-working spaces. Essentially, if someone's in and out of a co-working space, they could well be working. And that is being kind of kept an eye on. So a lot of people and a lot of employers treat Malaysia as a low risk from a remote working perspective, but actually that isn't the case. Thailand has what's called an LTR visa, and there are some digital pathways as well, but they have thresholds and they have requirements. And so if people cannot meet those requirements, then they aren't going to get the visa, and essentially they're going to be working and they won't have the permission. So there's a lot now of scrutiny in Thailand around working whilst on tourist visas, and a lot of more younger people who want to spend time in Thailand are getting what's called education visas as well. So the reality is they will apply for an education visa and essentially then not turn up to any classes. So technically they have a visa to be in the country. They're not studying, which is what they should be doing, but they're doing something else, usually trying to work. And there's a lot now of clampdown in relation to that kind of area. And again, Thailand has just again reduced the visitor visa period of stay from 60 days, which they extended from 30 last year, back to 30 days because there's too much misuse of the business visas and the visa exempt entries for a lot of nationalities in China, in Thailand. And finally, Indonesia. From an Indonesia perspective, what's happening in Indonesia essentially is there's a digital second home type visa, and that's evolving. So that the issue with Indonesia is any work or any activity, employment activity performed has to be authorized, plus has to be authorized for that specific location. So again, they're looking at co-working hubs, they're looking at long tourist stays, they're looking at people coming and going. Obviously, one particular area that is causing issues for Indonesia is Bali. So Bali is one area where, again, there's a lot of scrutiny about people coming and going because of the misuse of the visa requirements that people are entering on.
Okay. So it looks like there's some major sort of compliance issues there for, has this always been an issue in APAC, do you think, or has it become more prominent recently?
I think generally from the business visa perspective, it has been something where people have come, and especially visa exempt arrivals. I mean, there's a lot of people genuinely traveling as business visitors, but clients and particularly are looking potentially at project work. You know, if people are on projects and they only need to be in a country for maybe a couple of weeks or 3 or 4 weeks, but a work permit is going to take 6-8 weeks to obtain.
Right.
The authority, the employer will then say, no, I'm not going to do that. I'm going to just send them in as a business visitor. So yes, I think it generally has been an issue, which is why now there is so much more scrutiny and so much more compliance. And with the kind of introduction now of the digital arrival pods in, i.e. Singapore, in Malaysia, in Thailand even, you have to do a digital arrival card before you can even get through that digital thing. And so there's a lot of information that is now available to the authorities. The digital arrival cards are effectively now in place virtually everywhere. China's introduced them now, the Philippines has them, Singapore has it, Malaysia has it, Thailand has it. So you come and go now with a digital footprint, whereas before you didn't. And that allows the authorities a lot more scrutiny.
Right.
So the next slide really is about essentially, as we've just discussed, nominee and sponsor arrangements. Employers of record and nominees sponsoring work permits really are now something that the authorities, again, are looking at and clamping down on. The issue for this type of employment or this type of sponsorship is the questions, as we can see here, who actually is directing the work? It is not the person or the entity that is sponsoring the visa. So the employer of record is holding that visa and technically responsible for that person, but they are not directing what that person is doing. They hold the visa and then essentially have no more authority over that person. They then go off and do the work that they're doing for the employer that they work for, essentially. Who benefits from that? I mean, in sense, it's twofold. The employer of record or the nominee is being paid to sponsor that visa. So they are benefiting because they are being paid to take the responsibility for the visa. But they have no basically benefit on the output of the work that the person is doing. They have no control over it. They don't even know what they're doing. So there is a big issue there. And as I say, who controls the hours, duties, and reporting? Again, it isn't the person or the employer of record who is holding the visa itself. It is effectively the person who's working and likely just really managing themselves, because the reason you're using a nominee or an employer of record is because the main employer does not have an entity in that location. So that's a way around getting somebody into that location without essentially establishing your own entity. But you then, or the employer of record, will hold the visa. They will have responsibility for that visa, but they are effectively having absolutely no control, and they probably never even see that person. There's no reporting. There's no real connection between the person and the entity that's holding the visa and the person doing the work themselves. So it's very, very high risk. And when you look at where this is kind of happening, China is now looking at this because the reality is you have to have specific requirements for specific cities, even in China. You know, it's not one China work permit. It depends on which province you go in and which city you go in. So again, if an employer of record, as an example, is sponsoring this person to work in Shanghai, which would be the normal way this would work, that person is then heading off to go and work somewhere else. The only real person who's going to know what's happening is the person themselves. The employer will probably know which location they're in as well, but the employer of record will not. So there's a lot of misuse of this kind of situation in China. In Vietnam, again, the work contract has to specifically be set out, and it has to be a local contract. So the employer of record is holding the local contract, but technically the contract will be linked to the authority, to the regulations in Vietnam, but the actual terms and conditions of that person working will be very much around their own employer and what their own terms and conditions are. So there'll be two completely different documents, one of which will bear no resemblance to the other. And again, we've just looked at Thailand and Indonesia. Employers of record are starting to become effectively issues that both of these sets of authorities will now not accept. You have to have an entity in that location. You have to be kind of guided by what the location is that the person is going to be working in. Thailand, you have to be nominated to work in Bangkok, or if you're going to go and work elsewhere, it needs to be detailed on that work permit. And Indonesia, same thing. You've got to have that jurisdiction of where the work is taking place on the work permit. And if it's an employer of record, no. So generally, employers of record are starting to lose out because the authorities are now not accepting the terms and conditions under which these people are working in their own individual locations.
Right. So I think effectively they're working more in the space of local, because locally hired people are okay, right? If you're local Thai or local Singaporean or whatever, then EOR companies can employ and effectively dispatch, if I'm not mistaken. But it can't be foreigners coming in to do those roles.
No, yeah. That's right. And the other side to this is that the job titles are inconsistent. Where are the reporting lines? You know, are the reporting lines are primarily offshore? They're not going to be in that country, and they're not going to be to the employer of record. You know, email domains. What email domain is the individual using? Probably nothing to do with the employer of record. You know, access to systems, different brandings from, you know, there's a lot of things that really are non-compliant from this perspective. You know, technically, although it is a legal situation where you have an EOR and you have an employee, from an immigration perspective, it's very, very much from a compliance perspective, something that is now not acceptable.
Okay, good information. Thank you.
Renu, sorry, can you move to the next slide, please? Business travel, I mean, I think we're all probably very aware of business travel. Why has it become a major issue? So it's really historically been treated as low risk, low touch. That's not an assumption that's valid anymore. It's a leakage point. It's a compliance leakage point, especially as I mentioned, where it's being used now, essentially instead of getting the proper authorizations. Enforcement activity that's now in place is very much around a shift from not just ignoring it to actually active border level monitoring. This has really come about by the traveling that started after COVID. Hybrid work models where a lot of employers, which again links to COVID, essentially allowed people to go wherever they wanted to go in the grand scheme of things and work remotely. And again, without the right authority to do so. There's a lot of pressure now, as you mentioned, Steve, in relation to protection of local employment. You can't just be traveling as a business visitor and start working, because there is probably locals there that can do that same job. And as we've mentioned, the technology, the data sharing. So that's essentially what's happening. Serial travel, we've mentioned, there's a lot more ability now to track from a data perspective. You can't come and go regularly and expect to be admitted without any questions. And if the immigration officer is not happy, then you run the risk of being refused entry. So that is essentially a real issue. And, why are employers continuing to do this? The issue is, as I mentioned, that in a lot of cases, there is pressure from the employer to have something done. But the work permit application process will not necessarily allow them to do that quickly. So business planning is really critical. You need to have some forward thinking about where do you have a need, what kind of need do you have, and how long is it going to actually take to get that work permit, and then plan around it. But there is a lot of pressure from a business perspective for people to just go and do what they need to do. Cost avoidance as well. Some visas are very expensive. Australia, as an example, visas are very expensive. And some employers feel that it's quicker and easier to just let their person travel, and then they don't need to pay out for the relative visa. I've kind of thought that short stays aren't enforced. Now that is not valid. Short stays are being monitored. Short stays, repeated short stays, are being monitored quite closely. Employers need to understand that now. And I thought that everyone's doing it. Potentially, yes, and that's something that might still be valid, but it doesn't make it right. At the end of the day, if other people are doing it, they are not compliant. That does not mean to say that essentially you, as an employer, follows that line. You have to be compliant. So it's really important. Until someone is actually detained or deported, then an employer will probably run that risk. But then they're running into big problems, because not only if they're misusing the business traveller side, that can then affect any other work permits that they're potentially holding. They could all be cancelled or revoked, or it could be the case that essentially the authorities are saying, you're having no more work permits for another year, we're not renewing anything, and penalties as well. So there's a lot of implications for non-compliance. So the fact that maybe the thought that everyone is doing it is a good one. It's
That's not to mention the other sort of, if you're doing these repeat sort of business trips into countries and staying a month or 2 months and then going and coming for another couple of months, there's also some probably tax compliance issues that could come up too. And if,
that's a very fair point.
You're being well
a lot of
tracked,
countries, a lot of countries do have specific tax thresholds, don't they? If you spend a certain amount of time, usually it's 90 days or 180 days. But if you spend a reasonable amount of time in a country, yes, there will be tax implications as well.
Lots of things to look out for.
Absolutely, yes. I'd like to kind of highlight now right to work. As I mentioned, the issue of right to work essentially is the fact that there are obligations for right to work. So essentially, the right to work refers to the legal permission, both from the individual's perspective and from the employer's perspective. And what's happening at the moment is that there are a lot of inconsistent checking going on. Checking is not being done consistently, correctly, or at the right time. The common issues are that checks are starting after the person has already started work, or that incorrect documentation is being accepted. Digital status is definitely misunderstood because, again, like we mentioned, that people aren't now having stamps in passports anymore. So there's no real record of when that person arrived, what status they were when they arrived. An employer doesn't know, and they can't verify it, or they don't verify it correctly. And then otherwise, a lot of employers are not following up. If they're starting checks and they run into a barrier, then they're not following up. So from an immigration perspective, this very much undermines the statutory defense that an employer might have and signals weak governance. If you rely on digital systems, there are e-visas now, there are codes, there's online status portals in relation to right to work. There's also identity service providers, but a lot is happening in relation to hiring managers are assuming digital equals compliance, which isn't the case. They're using or allowing people to use screenshots to be saved rather than fully verifying records. So if they see a screenshot and it looks okay, that's it. They're not going back to verify the actual details. Sharing codes, they're not checking the live codes. There's no evidence being retained of who conducted a check and when it was conducted. So the issue here is, and the takeaway here is, immigration authorities are very, very clear on this. Technology does not replace accountability. You still, as an employer, have accountability. And the other side to some of this is that there's a lack of ownership amongst employers. So systematic concerns over who actually owns the right to work check. Is it the hiring manager? Is it the manager who actually is going to be managing the person once they come in? Who owns the compliance? And a lot of times, no one will.
Pulls through the cracks.
Exactly. And why is this escalating now? Well, the trends that are really showing up, as I've mentioned here now, digitalization, you've got to be very, very careful now. Authorities can more easily detect inconsistencies from a digitalization perspective. You know, there is a lot of there is an agenda in a lot of countries to protect the local workforce. You know, there's a lot happening economically, and the local workforce will always come first. So there needs to be protection around the local workforce, and which is why the right to work in a location is really important. Cross-agency.
How does this kind of work? So there's two sides to you know, right to work, right? There's the employer side, and then there's the employee side. What's the sort of compliance on the employee side?
Okay,
you know, what have
so
they got to look
essentially,
out
like
for?
we've said, you know, there's two parts to this. The term right to work essentially relates to the legal permission to be able to work in any one location. So there's a responsibility on the individual, and there is a responsibility on the employer. The concept of this applies to both. So for the individual, it's having a lawful immigration status in a location that permits employment for a specific employer, in a role that's permitted and in the right location and for a specific time frame. So the individual has to be essentially sure that they have that lawful immigration status. From the employer perspective, they have an obligation, as we've kind of highlighted here, to verify, document, and monitor every individual that they employ. But they've got to do it in a way that shows that person has the ability to effectively be in the country legally, and then legally be able to work in that country. Right. And there's been quite a lot of crossover on this from the Brexit perspective in Europe, because clearly prior to Brexit, UK was part of the wider EU, and everyone could come and go both into the UK and out of the UK or through Europe, right, to work. And of course, the minute Brexit was then approved, that stopped. And there were a lot of people that got caught up in this on both sides, British people in Europe, Europeans in the UK, that essentially never regularized their status. And there's been quite a lot of ongoing work to have that rectified, where people have essentially had to leave. And of course, there's been an implication to the employers as well, because they've lost people potentially that they wanted to keep. And, you know, essentially they haven't been able to do that because there's no legal right to work, because no one thought to regularize the stay. Thanks, Reddy. Could you go to the last slide, please? This is the final slide, and essentially this is really the top 10 essentially compliance perspectives that I would recommend that we kind of look for and highlight. The first one for employers is to ensure that they maintain accurate, up-to-date employee records. That is critical in case you decide to be audited. Immigration authorities can come into your office at any time. You need to be able to show the authorities as an employer, again, everything that we've discussed, that the person is legal in the country, he has the right visa, and he has the ability to legally work.
This also kind of applies to labour testing and that sort of thing as well, to have
the labour market testing,
labour market testing records. Yeah. And, you know, and I've personally had, you know, situations myself with the immigration in Singapore, you know, MOM requesting or denying, you know, applications, and then having to appeal, and, you know, make it clear to the authorities, you know, exactly what has been done, you know, for labour testing in Singapore and advertising. Absolutely.
Jobs. You have to document that you've actually essentially Singapore, the fair consideration framework, that you've actually really applied the fair consideration framework, which is not always straightforward potentially if you're an employer and you've identified someone for an assignment overseas, but you still have to go through that process in order to ensure that you get the employment visa. But then equally, as you quite rightly say, Steve, you have to actually retain all of those records in case the Ministry of Manpower want to see them. So all immigration, all people that are on employment passes, work visas, work permits, track the expiry dates. You know, as an employer, again, coming back to the legal compliance, if the visa is valid, that's fine. But if it expires, that person is then working illegally. So you need to ensure that you build in enough time to get the visa renewed, if that's what you would like to do as an employer. So much as you may have vendors out there who are doing that for you as well, you need to ensure as an employer that all immigration expiry dates are tracked. And that also includes anyone who's there on a business visit, because yes, they will have arrived, and yes, they will only have a certain period of time. You need to keep an eye on that and track it, definitely. Consistency across documentation. Make sure that documentation is consistent. You know, if you have assignment letters, make sure they're consistent. If you're providing employer reference letters, make sure that they're consistent. Again, this is related to audits. Make sure that everything that you have is consistent and that you're not authorizing or issuing documents that are different for one employee to another, especially if they're on the same type of work permit. It all needs to be consistent. Obviously, we've discussed this, robust document retention records. You know, if you have an immigration vendor, a lot of the documentation will be retained by your vendor as well, but you as the employer have to retain that documentation. In a lot of locations, if there are changes to employment conditions, now that could mean a change of role, change of responsibilities. It could be that somebody gets promoted. Anything that actually changes the original job description that has been presented to immigration needs to be reported to the immigration authorities. And again, that is something that usually isn't done. And if an audit happens and they come in and they see someone who's doing a completely different job to the one that effectively the work permit was authorized for, that can become a compliance problem for an employer. As we've said, preparation and business planning, visa processing can be time consuming. It's different in each location. In some locations, you can get an employment pass in 5 to 10 days. In other locations, you've got to wait 6 to 8 weeks. If it's Australia, you've got to wait 3 months at the moment if you want a sub-class 482 visa. So you have to plan accordingly. And don't think that there's other avenues for you to use to get that person in. Australia is a good example of this, because quite a lot of employers now, knowing that with all the changes to the regulations in Australia, they want a subclass 482, which is the employment visa. They're not an accredited sponsor. So that is going to take, I don't know, 12, 16 weeks to obtain now. So what they will potentially think is, oh, I'll get a subclass 400, which is the short-term work visa. And I'll get the person in, and technically they're compliant, and then we'll just convert from one to another. No, that's not acceptable. You have to use the right visa right from the outset. So trying to substitute one visa for another and have the person in country is not compliant. Yes, as employers, you need to do your own auditing. So that's really critical. Coming back to all of the points that we've raised already, your own auditing internally is really, really important. And again, strengthen your workplace compliance for auditing. So essentially just make sure that there is a program for checking, that everything is being done, and that, you know, you're going back to essentially ensuring that all that documentation is in place. And again, as an employer, there may be some training required internally. So maybe you can go to your immigration vendor, or to someone who can give you guidance on what to do to get ready for an audit, or have your own vendor help you with that. But the critical point for all of this is compliance first. A compliance first culture will ensure that as an employer, you do not have any problems, and that all of the employees that come into work for any of your companies are legally there. They have the right visas, and you will then have no problems.
Okay. Well, thank you very much, Debbie, for taking us through that. This is actually part one in a two-part series. So we will be coming back with Debbie, and perhaps maybe Debbie some others from the industry to talk about some other issues in the immigration sector here in Asia. Up on your screen there, we have the save the date for our APMA conference that is coming up this year. If you remember, last year we had our conference in September. I've actually moved the date a little bit to the 19th of November this year, so please do save that date. And more information will be coming your way about our one-day conference, in-person conference in Singapore. There will also be a virtual component to the conference like there was last year. So you can join virtually as well. And of course, we would love everybody that has joined us today on this session to become an APMA member. Please do consider it. We do the best we can to make it very affordable. One membership, annual membership, is just $300 per annum. And for example, if you are a member, you will get discounted rates to the conference that I just mentioned today. $200 for additional members. So if you're a company and you want to have multiple memberships, the second, third, fourth, fifth, and any additional memberships will just be $200. So we try to keep our fees very reasonable. We want to be inclusive and have lots of different people from different perspectives joining us here at APMA. So thank you very much, Debbie, for today.
Thank you.
I don't see any questions. There was a question about recordings. This is being recorded, and recordings will go out to all the registered participants. I will wait another 30 seconds or so as Debbie says her goodbyes to see if any questions come in, but at the moment we don't have any. So it looks like
But thank you very much. I hope this has been helpful. The second session is actually going to be on the 9th of April, and we will advertise that. So if you're able to register for the second session, that will be really, really good. But it's been a real pleasure to be able to be with you today. So thank you very much.
Okay, and we're going to finish up a couple of minutes early. So thank you very much, everybody, for your attendance today. And I look forward to seeing you at future APMA webinars. Thank you very much. Thank you, Debbie.
Thank you. Goodbye.
Okay, thank you.
Bye.
Bye.